You can stand to the podium, Mr. Gray.
I'm sorry, Your Honor.
I'm ready. You can
Okay.
stand. Okay.
Sorry, Your Honor.
All right, Ms. McClung, you can hear us clearly, right?
Yes, Your Honor.
Okay, thank you. This is case number 234561601, the people versus Shannon McClung. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Kristen O'Leary on behalf of the people, being ready to provide your
Good morning, Your Honor. David Draper on behalf of Shannon McClung, who appears via Zoom, IP number 43750.
Ms. McClung, your name, please.
Shannon Kathleen McClung.
Thank you. Today is the day set for pretrial conference. Counsel, how do you proceed?
Your Honor, we had an opportunity to speak with the people. We are obtaining a little more discovery. It looks like that will not be a problem. We would ask to come back in whatever time is appropriate for the court and ask if the complaining witness would be available at that time.
Thank you so much. All right, the court is going to continue a not guilty plea on behalf of Ms. McClung. Set the matter for final pretrial conference. Ms. Ritter, is there any digital discovery?
There is judge and the people essential, Mr. Gregory.
Oh, okay. So then, a March date for final pretrial conference is sufficient. Court is going to set pretrial conference, final pretrial conference for Wednesday, March 13th, if that's a good day for you, counsel.
Yes, sure.
All right. March 13th at 9:06, the complaining witness should be present. Anything further?
Nothing at all, Your Honor. Thank you so much.
Thank you, Judge. Thank you.
All right, then, we are all set. Bond will continue with no contact with the complaining witness.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome. All right, I'm ready on Zia. Or Zia. I'm sorry if I pronounced your name wrong. This is case number 194653801, people versus George Ramon Zaya. The defendant is charged with 1 count of trespass. Today is the day set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina O'Leary on behalf of the people.
Good morning, Your Honor. May it please this honorable court, Attorney David Newman, PA 2515, appearing on behalf of the defendant, George Zaya, who is present via Zoom. Mr. Zaya, please state your name for the record.
George Zaya.
All right, today's the day set for an arraignment on a bench warrant, but, 2 things. This is your case, Ms. Ritter.
I just saw that.
All right, so the appearance of the state prosecutor is not right, Mr. Bryant. It's not her case.
Okay.
The second thing is, it appears that this case is, it appears that the case is post-conviction, that Mr. Zaya was uh, sentenced by me, no, by Judge King. Um, for 12-month non-reporting probation, Gamblers Anonymous, Gamblers Council. He was supposed to return for review February 19th, but as to the arraignment on the bench warrant, how do you wish to proceed?
Yes, Your Honor, we'd like to waive the formal reading and stand mute.
Court enters a not guilty plea as to the arraignment on the bench warrant. And we'll move immediately to a review of sorts. It says it was a non-reporting probation, but your client failed to appear at his 1-year mark. He was offered a delayed sentence. However, he didn't come back. Counsel?
Yes, Your Honor. To my knowledge, Mr. Zaya had completed the 12 months non-reporting. There was an outstanding balance that he still owed. I believe it was under $500. He completely had no idea about this. He thought the case was all over with. He recently got.
Now, counsel, how could he think the case was over if he still owed $500?
Your Honor, I apologize. Go ahead, please.
You go ahead and tell me why you are saying that your client thought it was over with and he owed $500.
Yes, so he recently got pulled over for a traffic stop. He was cited by a state trooper. That's when the trooper explained to him that there was a bench warrant for his arrest. And then the trooper asked for a $500 bond for him to be placed for a court date for an arraignment. That's when he contacted me and let me know what's going on. And we dug a little bit deeper and we realized that for this case wasn't closed for the outstanding balance that was still owed.
No, the case wasn't closed because your client failed to return to court at the appropriate court date, and he failed to complete all of the terms and conditions of his probation. Mr. Zale was represented by counsel. He was represented by someone named Edward Trojanowski. If he had any questions about what he was supposed to do, then he was supposed to contact the court and or his attorney, and he failed to do that. He has not completed any terms and conditions of probation. As far as the court is concerned, he has presented no proof of gamblers counseling. He has presented no proof of Gamblers Anonymous. And he has clearly not paid the fines and costs that were imposed by Judge King. So it's confusing me that you're saying that he thought he was finished and that the only thing he had to do was pay $500. And those two things are opposed to each other also. I can't be finished and owe money. Those two things don't go together. I either don't owe money and believe I'm finished, or I know I'm not finished because I owe money.
Absolutely. For the record, Mr. Zay, did you complete those terms?
I did my gamblers counseling, and it was emailed over from my counselor to the probation lady at the time. And I believe, let me see if I have her name in here still. I can't find the name of my old probation lady, but she did get confirmation of the approval.
Officer? You can't find the name of your probation officer?
Yes,
Okay,
out of Wayne, the one in Wayne that was assigned to me.
well, yes, it would be out of Wayne, because that's where I am, in Wayne County.
Yes, ma'am.
Call Mr. Farmer and see if she was a probation officer. It's a non-reporting probation, so I don't know why he would have a probation officer, but call and see if that's her. So if your counselor sent over Gamblers Counseling, what about the Gamblers Anonymous?
George, did you complete that as well?
No, I wasn't aware I had to do that one.
Do we have the original? We don't have the original probation one.
This should be on that side. It's not there.
It is.
Oh, okay.
So when people say they weren't aware, and I have an order of probation that was given to them, that says to me that they were intentionally unaware. So if the judge did an order and the order says Gamblers Anonymous and Gamblers Counseling continue with GED, no casino, and a review date, and an amount owed, how does one then say they weren't aware? He said he wasn't aware.
Your Honor, if I may,
Yes,
I've had a recent client actually in front of you for a similar charge. And after we got off the record, I had to explain to her as well that these two were different and not the same. Because she felt that the Gamblers Anonymous and the Gamblers Counseling was the same thing. So I'm
that's a self-imposed, counsel, that's self-imposed, because every person knows, for example, that Alcoholics Anonymous. So Gamblers
Yes.
Anonymous is the gambling equivalent to Alcoholics Anonymous. So if I say you're gonna go into treatment, or into counseling, and you have to attend Alcoholics Anonymous, we know that's two different things. So I don't know what his lawyer, said to him, but why would the judge waste their time to say Gamblers Counseling and Gamblers Anonymous if they're the same thing? We would only say Gamblers Counseling.
Absolutely, Your Honor. Absolutely. I just the reason why I mentioned is because she did have confusion, and I'm assuming that Mr. Zaya had the confusion as well.
Okay, well, let's see if he even did the counseling, and then I'll decide if he has to do the Gamblers Anonymous.
Thank you.
Oh, okay. I believe his probation officer, according to the register of action, notwithstanding the non-reporting nature of the probation, was Ms. Bumpus. So we're gonna try to find Ms. Bumpus, who is present in the courthouse today, and see if she received what your client status was sent to her, on this, with respect to the counseling. And then, and if she says, yes, she has the counseling, then I'll make a decision. Did he post a $500 bond?
Yes. December 15th.
Well, that's what, a $500 cash bond or a $500 10% bond?
Cash.
The police said they just gonna raise his bond? I don't even know why the state pay judges. It's just one of the most ridiculous things that they do with their money, pay judges, because everybody do whatever they wanna do. I don't even know why they pay judges, they just wasting their salary on me and everybody else, okay? All right, well, I'm gonna pass the case for a moment while we see, whoops, if we can track down Miss Bumpus. I say track down, but you know, she's working today, she might be in another courtroom. If she could check her notes, so that, I'm trying to prevent you from having to come back.
Thank you, Your Honor.
Since to the $500 bond, we could simply apply the bond to his balance. If he did in fact present proof of the counseling at that time, then I may just accept that. Do you know if your client is still on the disassociated persons list? Oh, wait, no, it wasn't gambling, it was trespass.
I believe that's what it was for, Your Honor. It was a trespass for being on the dissociation person list for the casinos.
Do you know if he's still on the list?
Yes, I
Mr.
am, Your
Zay.
Honor.
Okay,
All right, well, of course, as long as he's still on the list, then he can't go into the casino. All right, while I'm waiting, I'm gonna let some more people in and then,
Thank
see
you,
if
Your Honor.
All right, so I'm gonna put you back in the waiting room, counsel, if Miss Bumpus doesn't respond in the next 5 minutes, then I'll go ahead and give you another date. He's gonna have to contact Miss Bumpus. I think Miss Bumpus is probation officer.
It is,
So
Your
you'll
Honor.
have to contact Miss Bumpus, but I'm trying to prevent you from having to come back, okay?
Thank you, Your Honor.
All right, so give us a few minutes.
Thank you.
You're welcome. All right, let's see. Let's disable this. Does anybody know about Moses? Is Moses on my God? There's no Moses. I don't know.
Hello.
Just in case it's-
Ms. Moses, good morning. Unmute yourself.
Good morning.
Ms. Moses, you're a day early. We'll see you tomorrow, ma'am. And I hope.
Thank you.
What time is she supposed to be? Okay, because you late too, so 8:30 tomorrow. 8:30 tomorrow.
8:30 tomorrow.
Yes, ma'am.
Okay, thank you.
I want you all to stop coming in Zoom saying hello. You're not calling in on somebody's telephone. You're logging in the court.
Always catch up time on Wednesday.
You're logging into court. Can the person on the non-video telephone please press star mute to unmute yourself? Your phone number ends in 3690. Your phone number ends in 3690. I need everyone else to stop unmuting yourself. Stop unmuting yourself. Stop unmuting yourself. Do not unmute yourself unless you are asked to do so by the court. Can the person on the non-video telephone, your phone number ends in 3690. Can you please press star 6 to unmute yourself? Please state your name for the court.
Darrell Kendrick.
Say that again.
Darrell Kendrick.
Is this your witness, Ms. Ruth?
He's on the document grade 30.
Oh, Kendrick. Mr. Kendrick, I'm gonna send you to a breakout room. However, you have to be on video. They're gonna try to help you get on video, but you have to be on video or you have to be in person.
Well, I see the courtroom.
Sir? Okay, that's what we're gonna do.
Okay, I see the courtroom.
Okay.
Oh,
Sir, stop saying hello, please. I just said we're not we're in court. I need everybody to pretend like you're standing at my podium. Okay, I'm gonna send Mr. Kendrick's device to the breakout room.
okay. Is it like butterfly? I don't know.
Whoever that is, okay, let's mute Mr. Kendrick while I'm trying to send him to the breakout room. Okay. Okay, I need the person identified as Moto Dom to unmute and state your name. I just sent you a prompt. State your name.
Dominique Terry.
Ms. Terry, you're not on my document. Ms. Ritter, is this your witness?
It is, Judge, for Cunningham, case number 0.
Okay.
I'm renaming her name.
The person on this iPhone that I'm sending a prompt to unmute, please unmute and state your name.
Keisha, good morning. Keisha Ragland.
Ms. Ritter, is this your witness?
Is that Ms. Radley?
Oh, yes. Okay, never mind. I saw another different rag.
I did too, Judge, but
But no, she's at 8:35.
oh,
Person on the Samsung SMG998U that I'm sending a prompt to, please unmute and state your name.
Malcolm Blaylock.
Thank you. Mr. Blaylock, you almost an hour late for court. All right, can the person identified as Jasmine Lowe unmute and state your name? And state your name.
Jasmine Lowe.
Ms. Lowe, you're not on the docket and the people say you're not their witness. What brings you to court today?
It's a domestic violence case, but I don't know which courtroom to join. She only gave me a.
So you said I'm gonna just join Judge Bryant's.
No, I joined another courtroom and they told me Judge Bryant is the court, the judge that takes domestic violence cases.
Who told you that? Can you tell me which courtroom you logged into?
Let me go back to I think it was, I joined all of them. That was just the first one that actually picked up.
Which one was it?
It was a woman that told me that. Which one
Ma'am,
did
do
I
you know
join?
which, when you log into, you know how many, it's a lot of women that work in 36th District Court. I'm asking you, which courtroom did you log into, if you know?
I think it was the Ronald Giles one.
Okay, call the Judge Giles and see if they told somebody to log into me. And why would they tell somebody I do domestic violence?
Do you happen to know
Now,
which
I don't
judge it
handle
was?
domestic violence, ma'am, listen to me. I don't handle domestic violence. Please log into Judge Austin Garrett. If it is a domestic violence case, the judge is Austin Garrett. His Zoom ID number is almost identical to mine. If you log in using the Zoom ID number, just change the 9 to an 8. If you logged in by clicking on my name, then go to the website and click on Judge Austin Garrett. And everyone in the building should know that Judge Austin Garrett is the only judge in this building that handles domestic violence cases unless they are felony cases. So if it's a felony case, then it's not gonna be Judge Garrett. But I'm gonna send you to Judge Garrett because he's the misdemeanor domestic violence judge, okay?
Thank you.
You're welcome.
She said nobody gets that signed in. They don't let anybody get that's not on the document. That's what she just told me. She didn't get a call. She didn't see anybody here.
All right, this Motorola is still not, connecting, so I'm gonna remove the Motorola. And, everyone else, did we hear back from Ms. Bucks?
No, we can't.
Everyone else, please start your video. Ms. Stevenson, can you all go into that breakout room and help the gentleman get on video?
Yes, Your Honor.
I need everyone else to please start your video.
All right. Okay. Okay.
I need everyone to get stationary. I need you to be seated in an upright position. I need you to be in camera and ready to attend court. I need everyone to be stationary, seated in an upright position, in camera, ready to attend court. That includes the complaining witness. I need everyone to be stationary, seated in an upright position, and ready to attend court. I'm going to send you to a breakout room. Please accept to join the breakout room. Please also understand I'm not competing. I'm not gonna compete with whatever you have going on right now. If it's not dealing with court, I'm not gonna compete with it. And that means that you're not in court. That means that you're not here. That means that you're not present. I'm definitely not gonna be, okay. So Ms. Ritter, I'm gonna remove your witness, because I don't know what's about my language that's not being understood. Okay, all right. Mr. Blaylock and Ms. Ragland, please accept to join the breakout rooms and wait for someone to come in to speak with you. Do not leave the breakout room until you have spoken with the lawyer. And then, I suppose I'm gonna go ahead and send Ms. Terry, but this isn't gonna work. All right, and then do you have another witness in the room?
I didn't know she could break our rules.
Okay, so you can go ahead and talk to both of your witnesses. Ms. Terry not ready, she not in court. I'm just gonna let you know that, but you can go talk to her.
I'll look right to it.
Okay.
Ms. Bumpus is getting the documents together. She'll be down to the courtroom shortly.
Oh,
I talked to Ms. Coulter yesterday afternoon. She said she has some matters. She's gonna try to be in it.
that's fine. Ms. Stevenson, you can go while Ms. Ritter talks to these two witnesses.
Yes, Your
And
Honor.
try to get that Mr. Kendrick ready, the prosecutor is here. Ms. Kendrick. Mr. Newman, I just wanted to let you know we did locate Ms. Bumpus and she's pulling together her file. She's getting her file, so I'll be with you shortly. I just didn't want you to think I forgot.
Okay, thank you. Also, Your Honor,
Yeah.
just for the record as well, Mr. Zia, did tell me that his counselor was named Mike Mooney at the time. That's who should have sent it over to the probation officer.
Oh, I don't have that person in my system. I had whoever name I said, but okay. So maybe tell her that's what well, she'll know. But,
Okay.
okay.
Thank you.
Okay.
Your Honor, I believe that was Mr. Kendrick on the phone and he's no longer in the breakout room.
Oh, wow, what happened?
I'm not sure. It sounded like he was also on another device.
Oh, I don't think so. That's not what it sounds like to me, but I'll bring in these two unidentified.
Okay.
Oh, you're saying because, um, you're saying because, he said he could see the courtroom?
Yes, Your Honor.
Okay. Let's see if there's, I don't know. And I take it you didn't write down that phone number?
No, but I think I do. I have Mr. Kendrick's phone number. I can call him.
Yeah, why don't you call him, because the prosecutor is here.
Thank you, Your Honor.
Okay.
All right.
Mhm.
Chief Judge wants to speak.
Okay. They still don't sound, I don't know who they are. Yeah, sure, that's cool. Since they're calling to tell you. Can the person on the Galaxy A20 please state your name? You unmute, please. Can the person on the Galaxy A20 please unmute and state your name? Okay, I'm getting ready to remove you from the courtroom. Thank you so much for coming. All
I
right.
think that was Mr. Kendrick on yet another device, so I'm
Okay,
on the
then
phone with him now.
say some stuff, Ms. Gibson. Okay. Okay. That was you calling them that made the sound, so now.
Yeah, I think it was.
Okay, well, tell them to come back.
Okay. Okay.
Ms. Stevenson, come on up, Ms. Bumpus. Oh, come on up, Ms. Bumpus. Whoops, hold on, I didn't even do that, but all right. Mr. Newman. And I was trying to bring in Mr. Zaya. All right. Okay, back on the record with case number 194653801, people versus George Ramon Zaya. Okay, Ms. Bumpus, let me get your appearance, please.
Yes, good morning again, Your Honor, Lori Bumpus on behalf of the probation department.
All right, so we, of course, Mr. Zaya appears before the court today on an arraignment on a bench warrant. And with respect to that, the court noted that he was previously placed on non-reporting probation by Judge Kenneth King, but it said you were the probation officer. And Mr. Zaya indicated that his previous attorney forwarded his counseling records to you. So that's what I was having you come in to let me know.
Yes, Your Honor, after reviewing the file, we do have proof that he did complete the gambler's counseling as ordered with Mr. Mooney, July 2nd of 2020.
Oh, so Mr. Mooney was his counselor, not his lawyer. I was confused. Okay.
That's correct.
Thank you, counsel. I misinterpreted what you said. Okay, so he did complete the gambler's counseling.
However, he never submitted proof of attending the GA meeting.
Right, because he didn't go. He said he thought they were the same thing. So I was just trying to see if he did the counseling, if I was going to waive the GA.
And he was also ordered, Your Honor, to continue with his GED. At the time, I don't believe he was in school, but I did refer him to Wayne County Community College. They do offer the GED classes. I don't know if he ever enrolled, we never received proof of that.
What was the status of your client's education? Did he ever enroll in the GED classes?
Mr. Zaya, did you ever enroll in the GED class?
I did not.
Why not? You didn't want to get your GED?
I do actually still want to get it, but I be honest with you, I did not enroll in that.
Your Honor, I'm gonna talk to him about that. I want him to get his GED as well.
Well, I do too, but, you know, I don't know that I would have ever ordered it for this case. However, um, I guess the one problem, Mr. Newman, with the delayed sentence is that your client didn't pay within the 12 months. He didn't pay within the 12 months, and so I don't think he can get the delayed sentence. Unless, no, because his balance is now 5-something because 4-something because they added late fees and penalties.
Your Honor, by any chance, can we get that reinstated? It was quite some time ago. The money's not an issue for him. He can pay that. And we just want to close out this case, the way it was originally, judged upon him.
Well, the problem with that is the way that it was originally judged upon, the law says he has to complete it within 12 months. You can't delay a sentence longer than 12 months, and he didn't do it within the 12 months. If he had paid that money, then he would have been okay because he would have finished it in the 12 months, technically, not really, because he didn't do the Gamblers Anonymous, but I was going to accept that. This is what I'm going to do. I am going to indicate that the defendant did complete Gamblers counseling. He did not complete the Gamblers Anonymous, nor did he enroll in the GED, nor did he pay the money. So I'm not going to give him the delayed sentence, but I am going to apply his bond to the fines and costs outstanding. And then I will close him out without improvement. But he can't get the delayed sentence.
Okay.
So Ms. Bumpus, you can close him out, but it's without improvement.
Thank you, Your Honor.
All right. Hold on. What street do you have him living on?
It's I'm gonna spell it.
Okay.
EXETER, Exeter.
Exeter, do you still live on that street?
Yes, ma'am.
Okay, so we'll mail a copy of the discharge to you for your records. Anything further, Mr. Newman?
That'll be it, Your Honor.
All right, then we're all set. Have a great day. Stay safe.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right. You're welcome.
Thank you, Your Honor.
You're welcome. Thank you, Ms. Bond.
Your Honor, do I have 1 minute?
Yes. Is this Mr. Kendrick on the Galaxy?
Yes, ma'am.
Okay, now let's see if we can get you to start. Oh, wait, hold on. Let's see if I can get you to start your camera.
Okay. Start. We should
Okay,
connect.
now take off your hat and come sit in front of the camera instead of leaning over there like that. Come on and sit in front of the camera. Okay, give me 1 second. All right, Ms. Stevenson, you don't need to speak to Mr. Kendrick. I want to go ahead and get it while he's on video.
I appreciate that, Your Honor. Thank you so much.
Okay, so then this is case number 15443190 people versus Darrell Kendrick. Defendant is charged with one count of false unemployment compensation, and today is the day set for a pretrial conference. Appearances, please.
Morning, Your Honor. Fawn Armstrong, Assistant Attorney General on behalf of the people, P74980.
And good morning again. For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Darrell Kendrick. Mr. Kendrick, sir, please say your full name.
Darrell Kendrick.
Thank you. Today is the day set for pretrial conference, and I noticed this is a 2015 case, so is this properly set for pretrial conference?
Yes, Your Honor. I was able to review the online register of actions. It looks like a warrant was issued and the complaint was authorized in 2015, and he's just never been arraigned on it until November of 2023.
Okay, then with respect to the pretrial, how are we proceeding, Ms. Stevenson?
Thank you, Your Honor. Mr. Kendrick will continue his plea of not guilty. We would ask this matter be set for final pretrial conference, and I do believe the people have already set in motion plans to get discovery to us.
The court is going to continue a not guilty plea on behalf of Mr. Kendrick, set the matter for a final pretrial conference, March the let's go with April 3rd. And that's at 9:02. So, well, let me ask this question, because this has been a journey. We've taken a journey trying to get Mr. Kendrick connected to the Zoom. Now that we have arrived at connection, is Mr. Kendrick able to come to court on Zoom, or do I need to set this for an in-person? Because I'm probably not gonna do a 5-time try next time. Let's do in person, because everybody has.
Thank
9:02 is in person, April 3rd, 9:02, in person, okay?
Yes, Your
Yes,
Honor.
ma'am.
Thank you very much, and request that bond be continued.
Bond is continued.
Thank you, Your Honor.
All right, you're welcome. Have a great day, stay safe.
Thank you.
You're welcome.
Thank you, Mr. Kendrick.
Okay, let me update my docket with these witnesses. So, plaintiff witness on Cunningham, 608. And complaining witness on. Who was your other complaining witness? Oh, another Cunningham. Okay, 604. All right, I'm ready on Cunningham.
It's fine. I'll turn off the ROAs anyway. So.
All right, I'm ready on Cunningham. These are case numbers 234560401, 234560801, 234560901. The people of the state of Michigan versus Demario Tavion Cunningham. In each case, the defendant is charged with one count of larceny and one count of false pretenses. And as to each case, today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, I have the complaining witness for case number ending in 604, Ms. Felkins on Zoom. Ms. Felkins, can you unmute yourself and state your name for the court?
Kylie Felkins.
Thank you. And I also have the complainant witness present on Zoom for case number ending in 608. Ms. Terry, can you unmute yourself and state your name?
Dominique Terry.
Thank you. And Your Honor, as far as the charges for case number ending in 604, it's count one, larceny, 200 or more, but less than 1,000. Count two, false pretenses, 200 or more, less than 1,000. And for case number ending in 608 is.
Why are you repeating these charges?
Because I'm just putting them on.
Oh, okay, there we go, right?
Okay.
Okay. Are they different amounts?
Yes.
Oh, okay.
The case number ending in 608, both counts are less than 2.
Oh, okay, thank you, Ms. Ritter. All right, Mr. Moody.
Yeah, may it please the court. My name is Abdullah Mugni here on behalf of Demario Cunningham, who appears today via Zoom. Demario, could you please unmute your microphone and say your full name for the record?
My name is Demario Cunningham.
And what's your middle name, Ms. Cunningham?
Davion.
Thank you. Today is the day set for pretrial conferences. How are we proceeding, Mr. Moody?
Yes, Your Honor. And in the cases ending in 604 and 608, we're going to ask that those two matters be set for a final pretrial and request all discovery for those two cases. For the case ending in 609, we're going to move for a dismissal based on that complaining witness's failure to appear.
Ms. Ritter, with respect to the last case.
With respect to the case number ending in 609, Your Honor, I don't see the complaining witness, Mr. Hussein Masawi, logged in, at least in the waiting room. However, if the unidentified devices are not Mr. Masawi, Your Honor, the people will respectfully ask the court to adjourn that pretrial conference and give Mr. Masawi one more opportunity to appear before the court.
All right, give me one moment. I just let an individual in the courtroom identified as a Zoom user. Please unmute and tell me your name. Can the Zoom user please unmute and tell me your name?
Micaiah Haley.
Hey, Ms. Haley, that was real slow moving. I was getting ready to move. Ms. Ritter, is that one of your witnesses? Not on this case, but.
Not on this case, Judge, and I don't have a Ms. Haley on my list.
Ms. Haley, you're not on the court's docket. Mr. Cunningham, can you stop playing with your hair? Ms. Haley, you're not on the court's docket. Call the courtroom and see if the clerk can assist you. Are you ready to receive the courtroom phone number?
Okay, thank you.
That's yes, you're ready to receive the phone number? Oh, they don't want to call. Okay. All right. The Motorola isn't connecting. All right, so with respect to the case ending in 609. No, yeah.
Oh, let me find out. February 26th.
All right, with respect to case number ending in 609, the court is going to deny defense counsel's motion to dismiss. I will grant the people's request for an adjournment, giving them an opportunity to locate the complaining witness and inform the witness of their obligation to appear before the court. Yesterday, I set a case for Mr. Cunningham on February 26th at 8:36. I am going to set this matter for February 26th at 8:36 also. With respect to the two cases that are on the court's docket, where ending in 608 and 604, the complaining witnesses are present. The court is going to continue a not guilty plea as to those matters as well. Set the matters for final pretrial conference. I'm going to set those final pretrial conferences for April. And then if the other witnesses show up, I will put those final pretrial conferences in April as well. So I'm gonna set the final pretrial conference for April the 18th at, strike that, April 17th at 9 o'clock. Discovery should be submitted by March the 18th. And then Ms. Felkins and Ms. Terry, you have both appeared today and therefore your appearance is not required. Let me just make sure you both. All right, you have both appeared today and therefore your appearance is not required on April the 17th. However, as complaining witnesses, you can come every time there's a court date, but you're not required on April 17th. If you don't appear April 17th, just contact the prosecutor's office or the victim's advocate to see when the next court date is and whether your appearance will be required. It is possible that a trial date could be set at when we come in April, but you know, I don't know what will happen. So just keep in touch with the prosecutor's office. Bond will continue with no contact with the complaining witnesses. Anything further?
Yes, Your Honor. With respect to discovery, Judge, there are some unredacted Facebook pages. This alleged incident took place, well, starting with the Facebook Market Exchange, and there's over 96,000 pages of Facebook information that people have to submit. So I'm actually putting a court and defense counsel on notice that people intend to send a protective order because it's just so much pages of information.
But, okay, you help me understand, if it's 96, you said 96,000.
That's what I was told.
But if it's 96,000 pages, because you said it's unredacted.
Right.
Because it couldn't possibly all relate to this case.
I believe it's in relation to other cases as well.
Okay, so it's something dealing with marketplace.
On Facebook.
Okay, and I mean, yes, wait. Some kind of way I feel like I'm gonna think that it's gonna be the people's responsibility maybe, or some kind of way. Somebody has to redact it, or when I say redacted, I don't, somebody has to pare it down. Like we can't, because how would the people know not the people, you are the people. How would the defense know like what is relating to their client?
Well, it's generally, Judge, everything relating to the incidents that Mr. Cunningham has. So they're all related to the incident.
To Mr. Cunningham.
Right.
But
it's information for the complaining witnesses, information that people don't want to get out without being unredacted. Because it's so big, people could not, I guess.
Oh, I see what you're saying, because like on Facebook Marketplace, it might have their addresses.
Right.
Okay, I see what you're saying. Okay, yes, of course, of course.
Thank you, Your Honor.
Yes, okay, I understand better, okay. And so Ms. Terry and Ms. Felkins, just so that, you know, you are comfortable with that. I don't know if you quite understood what she was saying. So there's, I guess, information from transactions that you all may have done on Facebook Marketplace that may contain some of your personal information. I don't even know if it contains any of your financial information. I'm not sure like what the evidence is, but even with respect to like your addresses. So the prosecutor asked me for a protective order, protecting the information, making sure that the defense attorney doesn't share that information with, you know, anyone outside of the court's approval. So that's what that's what you're asking me, right?
Yes, Your Honor.
Okay, so yes, of course, absolutely. Okay, so anything, and that applies to all the cases, if that is what's going on. If the other witnesses show up, if that applies to those cases as well.
Okay.
Okay, anything further?
Yeah, Your Honor. Yeah, we have no objection to that protective order, Jack. And I have one.
Say, Mr. Movement, speak up just a little bit, or can we
Oh.
turn it up?
Yeah, sorry about that. Can you hear me better now?
Yeah, I'm gonna turn it up a little bit in here. Yes, Mr. Movement, go ahead.
Perfect. And I thought we have no objection to the protective order, but I would like a second to discuss the tether that is currently on DeMario's ankle. We'd like to have that removed as he has showed up to every single court date. He is going to continue down this pattern of showing up to all his courts. He is not being charged with any violent crime, so he's not a danger to the community. And Your Honor, I don't think there's really a point on having that tether on him at this time.
Ms. Ritter, your response?
Judge, again, I think he was arguing yesterday was due to the criminal history of Mr. Cunningham having other cases kind of relating to the same incident with these two cases in front of your honor. I'm gonna ask a question on that.
Ms. Stevenson,
Yes, Your Honor.
come in the courtroom for me.
Yes,
Mr.
Your
Moody
Honor.
is on Zoom, so I can't. Yeah, come in the courtroom. I want you all to approach for a moment. Mr. Moody, Ms. Stevenson is going to talk to you about what I'm getting ready to talk to them about, okay?
Hey, Judge, I'm going to step away for a second. Is it okay if Janice covers me?
Yes.
Wonderful, thank you.
Approach. Okay, Ms. Terry and Ms. Falcon, I need you to go back in the breakout room briefly. Oh, what happened to Ms. Terry? Oh, hold on, now she can't start again. Okay, Ms. Terry and Ms. Felkins, I need you to go back in the breakout room briefly. The prosecutor needs to ask you a question before I make a decision on the defense request. So I'm going to, why is the movie holding up my room? Okay. I'm going to send you both to, breakout room number 18. And the prosecutor's gonna come in and ask you a question. Okay, so Mr. Cunningham, just hold tight. Ms. Terry, accept to join that breakout room. Ms. Terry didn't go. Ms. Terry? There she goes. Okay. Yeah, okay.
I had 5 cases. One was dismissed yesterday and the rest of it.
Oh, yes.
Yeah, family college.
Oh, that's what it is. Okay.
Yeah.
Yes, okay, yes. So now he really only has 4 cases.
Yes.
All right.
Make sure your device is working.
I'm gonna stop there.
You see, if that's a person in the system.
I'm assuming this person might be here.
Marcus here.
Ms. Stevenson, did I send? Did I send you anything for the reviews for today?
I thought I got something. Let me see.
I thought something's upstairs though. I thought I sent you something. I left mine upstairs if I did.
Yeah, I got, it's not mine.
Did you get something for Harris and Matthew?
Let's see. I don't know these last names.
Hold on.
I got.
Oh, why did I send you that? I didn't mean to send you that. You could disregard Ms. Moore. That's not your client anymore.
And I don't
think so.
Nope,
Oh,
I don't think I
yes,
got
think
that.
Harris.
You
Harris,
did?
I think 822.
Okay,
Then I didn't send you anything for Matthews. Let me look to see if I have anything for Matthews.
Harris. Yeah. Yes.
Let's see.
Norris. Thomas. I don't see Matthews.
I didn't send you anything.
Okay.
I don't have anything. Can you see who Mr. Matthews, probation officer is? I don't have anything. All right, I'm gonna let this person in who I believe to be Harris. And then, did you all speak to Ledford? Because I have their name highlighted.
I think Mr. Mooney did talk to Mr. Ledford. I'll put a note next to him.
Okay, it looks like Ms. Ritter is back, so we're back on the record with Cunningham. All right, so, Ms. Dixon, put your appearance on the record.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Demario Cunningham.
All right, with respect to Ms. Cunningham, we had some discussion off the record. Ms. Ritter?
Yes, Your Honor. So I did have an opportunity to speak with the complainant witnesses. From my understanding, Judge, in the conversation that,
It's what you said it was at the sidebar?
right.
Okay. And for the record also, Mr. Cunningham now only has 4 cases because we dismissed the one yesterday because Family Dollar didn't show up.
Oh, okay.
Yeah, so he has 4 cases. 2 are definitely, proceeding further than today. And then the other 2, well, all of them are proceeding further, but the other 2, we were gonna see if the witness shows up on the 26th. So based upon that, the answer to my question, I am going to grant defense counsel's motion, and I'm going to remove the GPS tether for Mr. Cunningham. And then I am going to note that, so we're going to actually now change those cases, the times of those cases. So his case is on February 26th. I know I scheduled him for 8:36, but I'm gonna change it to 8:34. And then, his case on April the 17th, I'm gonna change it to 9:04. Mr. Cunningham, I really want you to come to court without us having to come find you. So I'm gonna remove the tether, but I do need you to come to court. If you don't come back to court, then I am gonna set a high bond, okay? He's shaking his head up and down, yes. All right, so Ms. Terry and Ms. Felkins, can you both start your videos for me? All right, so, as I said, you're not required to appear on that April date, but you can if you want to, and if you don't, check with the prosecutor. Thank you for your patience today. Unless there's something else for the record, we're all set. Anything else for the record?
It was at April 18th or 17th, Judge. I heard.
Oh, I thought I said the 17th. Did I say the 17th before?
April 17th.
Yeah, April 17th. Okay, all right, we're all set. Everyone have a great day, stay safe. Mr. Cunningham, give us until this afternoon and then you can go to the tether unit.
Okay, thank you.
You're welcome.
Have a good day, Your Honor.
All right, you as well. Oops. Okay. Okay, I'm ready on Reddick. Are we ready on Reddick and Blaylock?
Ready on Reddick and Blaylock, Your Honor.
Write one of your notes in the, write one of your notes that you be putting in the chat without my permission. You don't need my permission, Stevenson.
I always do, Judge, but do you want me to say anything in particular or just?
You know how you thank them for their patience, you know?
Oh, okay. Yeah, I like to do that. Okay.
Yeah, one of those. You thank
Okay.
them for their patience and stuff and things and such. All right, come on, Reddick. All right, this is case number 234555601, the People versus Justin Reddick. Defendant is charged with 1 count of malicious destruction of property. Today is the day. Mr. Reddick, can you be still? We gotta be stationary. We need to, okay. Defendant is charged with malicious destruction of property. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Janice Stevenson appearing on behalf of Mr. Justin Reddick. Mr. Reddick, sir, please unmute and say your full name for the record.
Justin Reddick.
Thank you, sir. Today's the day set for pretrial conference. How are we proceeding?
On behalf of Reddick, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, so the court did arraign this matter and set this for a pretrial conference requiring the complaining witness to appear. I don't see the complaining witness in the waiting room, Your Honor. And according to the notes from my victim advocate services, it looks like the complaining witness mail was returned to our office and her number is no longer in service. So at this time, Your Honor, the court unable to locate the complainant witness on this case and we will not be able to proceed. Of course, if that changes in the future, then we will consider refiling charges.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. People do have an explanation. The people have indicated that the mail was returned and the phone number is no longer in service. The court is going to grant defense counsel motion. The matter is dismissed without prejudice. Mr. Reddick, we will mail you a copy of the order of dismissal for your records. Have a great day, sir. Stay safe.
Thank you, Your Honor.
You're welcome. Yeah.
Jalen, I remember.
Disobeying a police officer? Oh, that ain't gonna happen. Well, he's not here today either, and that's probably gonna be good, because that's not gonna happen. Okay, I'm ready on Blaylock. This is case number. Oh, this already? Okay, case number 224462001, the people versus Malcolm Jamal Blaylock. Defendant is charged with 1 count of license plate illegal use, 1 count of driving while license suspended, revoked, or denied. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Malcolm Blaylock. Mr. Blaylock, sir, please say your full name.
Yes, ma'am. Malcolm Jamal Blaylock.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. On behalf of Mr. Blaylock, we continue the plea of not guilty. Ask the matter be set for final pretrial conference. Your Honor, we would request discovery.
Court continues a not guilty plea on behalf of Mr. Blaylock. Set the matter for a final pretrial conference. April the 3rd. At 9:00 a.m. with discovery being submitted by March 4th. Bond will continue with no driving without a valid license and no operating a vehicle without a proper registration. Anything further?
No, thank you, Your Honor.
Nothing on behalf of Mr. Blaylock. Thank you, Your Honor.
Mr. Blaylock, you're all set until April 3rd, sir, at 9:00. Have a great day. Stay safe.
Thank you. You do the same.
Thank you. I'm ready on Langford. All right, this is case number 18. Oh, I wasn't ready to wait. I'm not ready on Langford. Who's the probation officer?
On Langford. All right, thank you. I'll let her know. All right.
Let me see if she sent me something.
That was Miss Colbert's. Apparently she's in the waiting room. I don't know what name she's under.
You should ask her, because she's not in my waiting room.
She said it was 16th Circuit Court, but I think Veneer asked for her. But she said she has a hearing Cone County Circuit Court right now that she has to go to.
Oh,
She'll be back.
yeah, okay, because she wasn't there. No. I called Ms. Bumpers to see if she had any report on Langford.
Okay.
All right. All right, so, I'm ready on Ledford.
All right.
Mr. Ledford, start your video, please. right, this is case number 204410801, the people versus Daquan Ledford. Defendant is charged with malicious destruction of a building and malicious destruction of property. Today is the day set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf.
Janice Stevenson, appearing on behalf of Mr. Daquan Ledford. Mr. Ledford, sir, please say your full name.
Daquan Ledford.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
On behalf of Mr. Ledford, Your Honor, we move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Judge, so it's scheduled as a first time pretrial conference, and the complaining witness is actually the father of Mr. Ledford.
Mr. Ledford, I need you to sit up straight.
I am.
All right, Ms. Ritter, you said the complaining witness is Mr. Ledford's father.
Correct, Judge, and I don't see Mr. Glenn Ledford in the waiting room, Judge. However, people believe it should be a transfer.
Can the person on the telephone that I just led into the courtroom please unmute, press *6 and state your name?
Hello, my name is Deshauna Williams.
Ms. Williams, it's 10:20.
I know I was late, but I didn't have the computer that I had didn't have Zoom on it, so I did it on my phone. But I ended up calling up there and I talked to somebody before I got on.
What time did she call?
Maybe like 30 minutes. Probably like 30 minutes ago. I feel it was late regardless.
No, it wasn't 30 minutes ago. It wasn't 30 minutes ago. My clerk is sitting right here. It wasn't 30 minutes ago. And even if it was 30 minutes ago, you're late. You're supposed to be here at 8:30.
I know that, ma'am. I just said that.
Who are you talking to? Me?
Yeah, I know that I was late. I
Oh,
just said that
no. Yeah, I know what you said. Don't, let me say something to you, ma'am. Don't do that. Don't do that. That's rude. That's rude. Now, you're showing up late. You're showing up late, and then you're talking smart to the judge. That's rude. So I'm not going to hear your case today because you're late and you're late and rude. So contact the lawyer. Ms. Stevenson, you write down this phone number? Has she called?
I have her contact information, Your Honor.
Call her because she's late and rude. All right, with respect to Mr. Ledford, excuse me, Mr. Ledford, the court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set the matter. How many do I have on that February 26th date now? Well, strike that anyway. Let's go with February 28th.
Is that on this docket, Your Honor?
Yes.
17. February 20.
Oh, no, I'm sorry. Call Judge Garrett. I'm not. You said it's his father.
Correct.
Yes. Ask him is February 28th is the date or not. It needs to be in person because Mr. Ledford doesn't know how to appear on Zoom. He keep on going down and away from the camera.
I'm trying to, my phone is low. I can't hear. I'm putting the speaker up to my ear. I gotta hear you.
That means you need to come in person. That means you need to come in person.
All right, that's cool too. I've been coming to court for this since 2020.
Okay, I don't know who you talking to though. Mr. Flanagan, what's the court date? I don't know why y'all keep trying to talk to me sideways, crooked, and all other kind of stuff. We're not gonna do that. Mr. Flanagan, what is the court date?
February 28th, 8:30 a.m.
He's gonna appear in Judge Garrett's courtroom February 28th at 8:30 a.m.
Thank you, Your Honor.
Welcome. right, I'm ready on Murphy. Mr. Murphy, start your camera, please. This is case number 234562001, the people versus Harry James Murphy Jr. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the
Janice Stevenson, appearing on behalf of Harry Murphy. Mr. Murphy, sir, please unmute and say your full name.
Mr. Murphy, unmute and state your full name. Oh, wait, you can't unmute. Hold on, Mr. Murphy. Okay, now you can.
Good morning. My name is Harry James Murphy Jr.
Today is the date set for pretrial conference. How are we proceeding?
On behalf of Mr. Murphy, Your Honor, we would move for dismissal for the complainant's failure to appear.
Your Honor, I don't see the complaint witness, Ms. Amber Sanders, in the waiting room. However, Judge is scheduled as the first time pretrial conference, respectfully asking the court to adjourn the pretrial conference and give the Sanders one more opportunity to appear before the court.
All right, the court is going to continue, the court is going to deny the defense counsel's motion for dismissal, grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set the adjourn pretrial conference to February the 28th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
Not for the people, Judge. Thank you.
Nothing on behalf of Mr. Murray. Thank you, Your Honor.
All right, Mr. Murray, you're all set. Have a great day and stay safe.
Thank you, you too.
Murphy, I said Murray because I was listening to your attorney, Mr. Murphy.
I'm sorry,
Thank
Mr.
you. I
Murphy. I
appreciate that.
mispronounced
That's
your name.
okay.
I
I
apologize.
get it all the time. I get it
I
all the
didn't mean
time.
to
That's
do
okay.
that.
I'm used to it.
No,
I'm used to
don't
it.
get used to it, Mr. Murphy. I'm big on names. When people call you Murray, just say, it's Murphy. All right. So
Okay, I remember that. Thank you. You do the same. Bye.
All right. Can Marcus unmute and tell me your name?
I'm sorry, Your Honor. Marcus Harris.
All right, Mr. Harris, I'm gonna send you to a breakout room. Please accept to join the breakout room. The lawyer will be in to speak with you shortly.
Yes, ma'am.
All right, and then I'm ready on a Raglan. Let's see. Yes, I'm ready to Raglan. Did this want to say anything about, Blanford?
No, I'm calling her
I
back.
know, I might just have to adjourn, but it's a line. Let me just make sure. No, I already looked it up, didn't I? That was. Ma'am, can you adjust your camera, please, so we can see? All right, this is case number 224472301, the people versus Keisha Ragland. Defendant is charged with failing to stop at a collision damage accident. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Rivera on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of Keisha Ragland. My apologies. Keisha, could you please unmute your microphone and say your name for the record?
Keisha Ragland.
Today is the date set for pretrial conference. How are we proceeding?
So, Your Honor, today we're going to ask that this matter be set for a final pretrial and request all discovery.
The court continues a not guilty plea on behalf of Ms. Ragland. Set the matter for final pretrial conference, April 3rd at 9:04. Discovery should be submitted by March 4th. Bond will continue, but Ms. Ragland didn't come to court last time. If she fails to appear next time, her bond is gonna be higher.
Yes, Your Honor. And if I could for a second address that, she apologizes dearly. Her husband just passed away within the last month. And she's sort of been trying to put the pieces of her life back together. It's no excuse, but there's a reasoning behind it, and she's going to come to every court date going forward.
Okay, I'm sorry for her loss. You're saying I gave her less than a month, or I don't understand.
Oh, no. I'm just saying that she's been trying to put the pieces together for the past month in her life. It has nothing to do with this court. It's just on her end. She takes full responsibility, and she's trying to get her life back together, and she will.
Okay, in the court, again, I'm sorry for your loss. I set the matter for a final pretrial conference, April 3rd at 9:04. Anything further?
No, thank you, Judge.
No, thank you, Your Honor.
All right, then we're all set. Have a great day and stay safe now.
Thank you. You too. Have a good one.
Thank you.
Sorry,
That's gonna be a good work. All right, we're on a recess right now. Ms. Bumpus is preparing a report for language.
Okay.
Oh, that's the Townsend from the chief judge. That's his name. I just changed the date.
Why they ain't doing the minute? Why would we do it?
Oh,
No, they probably gonna do it.
oh,
Don't you think? I think they're gonna,
oh, okay,
or look, call them, make sure, but they shouldn't be doing it.
okay.
I'm not doing that. Let me try to work. This really still got too long.
Hey, Judge.
I said I was gonna bring Mr. Movie.
I'm sorry. This is
I said,
something kind of crazy just happened when I spoke to Mr. Harris. So I pop in and the guy's in tears, and I asked him what's wrong. And he told me he's in the hospital right now. He showed me he was in the hospital. His wife is currently in labor, and she's about to give birth to a premature baby that's most likely not going to make it.
okay,
Is there any way we could get this adjourned so he doesn't got to deal with this right now?
for sure,
Okay.
yeah.
What?
We'll take his phone number, you'll give him a day.
Okay, perfect.
Ms. Stevenson,
Yes, Your Honor.
you want to talk to Ms. Bumpus first before, and in case you need to talk to Ms. Langford again?
Okay, thank you, Your Honor.
Ms. Bumpus is gonna come
Yes,
out.
yes.
Okay.
Okay. Ms. Stevenson, are you ready on, Langford, or do you need to speak to Ms. Langford first?
I'm ready on Langford, Your Honor.
Okay. All right, Ms. Bumpus, you can come on up. All right, this is recalling, case number 186072601, People versus Danetta Lee Langford. Defendant is charged with child abuse, fourth degree. Today is date set for review. Appearances, please.
Hi. Lori Bumpus on behalf of the probation department.
Ms. Stevenson, when you start acquiescing to the probation department?
I always go after the people, whoever I'm going up against, I always go second.
It's a review. Go ahead.
For the record, Your Honor, Janice Stevenson appearing on behalf of Donetta Langford.
Ms. Langford, your name. Ms. Langford, you moving around?
Yes, I'm sorry.
Okay, ma'am, okay. I need you to be stationary. State your name for me, please.
Donetta Langford.
Hey, Ms. Bumpus, tell me the situation with, ma'am, I need you to be stationary.
Okay, I'm sitting down.
If I have to say I need you to be stationary one more time, we're gonna come in person tomorrow.
Okay.
Ms. Bumpus.
Yes, Your Honor. In this case, Ms. Langford was placed on probation January 3rd of 2019. At that time, the court did order that she have a substance abuse evaluation. It was determined that she needed outpatient treatment. She did successfully complete outpatient treatment at NCADD on May 6th of 2021. The court further ordered, Your Honor, that she have no alcohol or drugs, that she attend the parenting program. She did report that she attended 2 sessions at Pam's place. However, we never received documentation of that. The court also ordered that she attend GED classes. She was referred. We have no proof of that. It was also ordered that she pay any outstanding tickets. As of today, Your Honor, she owes $1,620 in probation fines and costs. And she owes a total of $372 in outstanding tickets.
Well, the fact that she's on my docket at 8:30 means she just is coming out of KP status, doesn't it?
Yes, Your Honor, and it was scheduled for review today.
And then her file is so thick and heavy. But Mr. Flanagan, what do these red dates mean on here? Like, why do they stamp those dates on here?
Look like date stamps. I don't know why it was stamped on.
You don't know? Ms. Stevenson?
Yes, sure. So to be forthright with the court, Ms. Langford does have a history of just not handling this case as responsibly as she should by failing to come to court on time. In my conversation with Ms. Langston, Your Honor, Langford, she does have the child who's the complaining witness here is right now living with Ms. Langford's mother. He's 16 years old and he's living with his grandmother at this time. Ms. Langford does have 2 younger children, ages 3 years old and 1 year old. They're in Ms. Langford's care and custody even as we speak. Ms. Langford has been struggling financially. She was seeking employment prior to being arrested on this case when actually she called the police, and when they got out there to investigate the situation, they ran her name and found the warrant, which is how she came into the Detroit Detention Center. She was arraigned and placed on a personal bond with a GPS tether, Your Honor, and I believe that that tether has been on since possibly since November.
You said she was arraigned and put on a personal bond?
She was given a personal bond with a GPS tether, I think.
By who?
Let me double
Okay,
check
well,
that,
about
Judge.
that, why did Magistrate Lapeer can't change my bond? The last bond that we have, that I have, is I set a bond $2,000, 10%.
And
I set a $2,000, 10% bond on August 22nd, 2023.
okay. Well, I think what the information I have is that bond is $50,000 personal, and I saw the tether that she has on.
Okay, well, I'm gonna
So,
find out why my
okay.
bond was, go ahead.
Okay, so then having that tether on, and I think it's house arrest, but having the tether on, according to Ms. Langford, has made it difficult for her to continue to look for work. In addition to the fact that she's caring for those 2 young children by herself. Having had the
Go ahead, Ms.
okay, having had the opportunity to speak with Ms. Langford, Your Honor, Judge, I don't really have anything that makes sense or anything that's plausible. Ms. Langford did advise me that she failed to submit to urinalysis. I think she was going to JAMS at one point, but told me that she didn't have any money to keep doing that. So she just stopped. So we had a conversation about that, and we had a conversation about how she told me that things are pretty difficult for her right now. And I just, kind of let her know
They're ready to get harder.
yes, that they would, because she has been convicted of a 1-year misdemeanor, and that it would be even more difficult for her to take care of her 2 young children and manage the things that she has to manage after getting out of jail after a year. So the court does retain jurisdiction over this matter, which carries a probationary period, I think, of up to 5 years. So there's time.
Why am I gonna keep on trying to beg Ms. Langford to do probation? I'm not. Her file is so thick. Her file is so thick, and it's not even necessary. And the reason it's so thick because she keeps getting arraigned on a warrant. She keeps not showing up. Why am I gonna beg her to do probation? I'm not. This is a 1-year misdemeanor, and it is punishable by up to 365 days in the Wayne County Jail. And Ms. Langford looks like she wanna go with that, but what I'm gonna do is, I'm gonna go ahead and call specialty court. Since there is so much time left, she's gonna have to go to specialty court. Now, I don't know if it's the mental health treatment court or the sobriety court, but she's gonna go to specialty court, because I'm not gonna beg her to do this probation. So the only thing that's gonna keep her out of jail right now is her participation in specialty court. She continues, she's not testing, she's not doing what she's supposed to do, and then all of a sudden, she's on a tether. Now, all of a sudden, her job, surgery, efforts are, now she can't look for a job. Well, first of all, who's going in person looking for a job? You're not going in person looking for no job. The job is on the computer. The application is on the computer. The everything that she needs to look for a job is on the computer. If she wanted to find a job, Kroger been hiring. They got, every time I go to Kroger, there is a sign at the Kroger that says they're hiring, they're looking for help. $15, $17. I went to some fast food place the other day, and they were hiring too. $15, $18. I said the people won. That wage for working at the fast food places is more than some people making when they come out of college. So let's be clear. Ms. Langford wasn't looking for no job. She didn't want to work. Because if she wanted to work, she could be working. It's so many people, they can't keep good health. A friend of mine closed his restaurant because he said, can't get no help. I'm trying to get help, don't want to work. So let's do this. Let's call specialty court. And I don't know which one. Which one? Did she do a mental health evaluation?
No, Your Honor.
Okay.
I think her issue was alcohol.
Okay, well then let's go to sobriety court. Let's call sobriety court. And tell them she got a lot of time, so 1 year misdemeanor. She got up to 5 years on probation. So I'm gonna have her evaluated by specialty court, and she gotta go to specialty court or she gotta go to jail.
Understood, Your Honor.
The file is too
I would
thick.
just say for Ms. I would just say on Ms. Langford's behalf here, and we thank the court. I think that that's an excellent resolution, and I hope it works out for Ms. Langford. You know, that with that child abuse conviction, and you know, and the multiple warrants for not coming to court, I think, you know, it's not as easy for Ms. Langford as it should be to get a job. So
Kroger don't care if she got convicted of child abuse. Don't do that. Kroger don't even care if she got, it's people working at Kroger and Meyer and stuff that got convicted of other stuff. And it's people working in the stock room. What they, okay. She's not engaging with the kids.
I know, Judge.
But,
I'm just going by what some of my clients have told me about losing jobs and not being with that child.
I know.
But it nevertheless.
You believe what your clients be telling you all the time. You should.
Until I get evidence to the contrary, I mean, I give them the benefit of the doubt. 100%.
I'm gonna go up in Kroger and ask the man who a felon, ex-felon, I'm gonna ask him, what was he convicted of? The man who was talking to me the last time I went to the other Kroger. And then I'm gonna just say, do you mind telling me what
Langford get a job?
Because the defendants who got the misdemeanors telling me that they can't get a job at Kroger, but you seem like you can get a job at Kroger. Okay, we're gonna
I'd
find
love
out.
that. I would add them to my list if that would help. That'd be great if we find out that Kroger is hiring records. I'd love it.
Okay, Ms. Stevenson. Sobriety court is gonna be logging in.
Okay.
And we'll let Ms. Bumpus know if she's gonna transfer all her notes to the sobriety court team.
Thank you so much, Your Honor.
You're so welcome. Look, Ms. Bumpus filed thick too.
Ms. Bumpus is really to be credited. That was the other part of my argument, that Ms. Bumpus has gone out of the way to work with Ms. Langford, and Ms. Langford remembered that too. So
yeah, but she gave Ms. Bumpus strength. Ms. Bumpus was trying to help her, and she don't want to be helped.
Yeah, she does want to be helped. I just don't know if she really has it to get that help now. She wants it. As to whether or not she knows how to make it happen. That's maybe the specialty court could help her with that. I think that's a great suggestion.
Okay, well, let's get, they're gonna log in.
Okay.
All right. Miss Coleman's phone.
I saw she just left.
All right, Ms. Langford, I'm gonna put you in the breakout room, and when the specialty court logs in, I'm going to send them to the breakout room with you. So please accept to join breakout room number 2.
Okay.
All right, well, are we ready on the other hearing? Because Ms. Colthurst keeps coming and going.
The other.
Are we ready on the other hearing? Because Ms. Colthurst. Oh, okay. Are we ready on Jones? Nope. I didn't see Ms. Stevenson go back there. Did you talk to Mr. Jones?
That is the first I heard that Mr. Jones is back. I'm coming in right now.
Okay. Is he upstairs or down? Okay. Well, then we'll let Ms. Stevenson talk to Mr. Jones. I don't remember this book. You got a witness? Yes.
Okay, it's Colbert back.
Okay, yes, I mean. All right, yes, okay. I'm gonna do the Moore case first, but you can stay right where he is. This is case number, this is case number 214548501, the people versus Regina Octavia Moore. Defendant is charged with 1 count of assault and battery, and today is the day set for a review. Did Judge Carter see? Yeah, okay.
No, I was just on the floor and I.
Oh, okay.
And then this needs to take this question.
Oh,
So
okay.
I had to come in and wait.
Oh, okay. All right, Miss Ritter, your appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Miss Regina Moore. Miss Moore, please unmute and state your name.
Unmute. Hold on, let me see what the settings are. Yes, you should be able to unmute. Unmute.
Regina Octavia Moore.
Today is day set for review. I set this matter with respect to review to see if there is a need for a bond violation hearing. And I understand that the prosecutor and defense has had an opportunity to review the video that was submitted by probation. Is that correct?
That is correct, Your Honor.
Ms. Coulter, you had an opportunity as well?
Yes, Your Honor.
All right, and then I also recall setting a second date in case we did need a hearing. So are we proceeding to that second date, or is there a resolution today?
I'll defer to Ms. Colbert.
Ms. Coulter?
It appears that there will be a need for a second date. The video does not pertain to the allegations that are contained in the request for the warrant for probation violation. And so it just doesn't seem to be relevant to the allegations. So I don't even know why that particular video is
submitted.
Yes, submitted.
Yeah. Okay. All right. What date did I give?
January 31st.
Okay, so we're gonna be January 31st in person. That hearing is gonna be in person. Ms. Ritter, have your witness available.
Understood, Judge.
At what time did I say? 11 a.m. January 31st in person. Okay?
Yes, Your Honor.
All right, we're all set then. Have a great day. Stay safe.
Thank you, Your Honor.
Thank you, Your
And
Honor.
likewise.
All right, thank you. All right, then we're all set. Okay, then I'm ready on case number. Well, we need to find this 8 here. All right, I'm ready. This is case number 234573401, the people versus Cleophas Jones. Defendant is charged with 1 count of stalking and 1 count of communication services illegal use. Today is the date set for bond violation hearing. Appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people, P number 83505. Your Honor, I do have my officer in charge, president of the courtroom, who is seated behind me. Would you like to get this?
Yes.
Sergeant Donald coming to the Detroit Police Department.
Thank you.
And then I also have Corporal Smith, who is also present, who submitted the violation report. Corporal, would you
Oh, yes.
Robert Smith, Wayne County Sheriff Deputy.
Okay,
Would you like to complain?
no, not right now. And who was that came in here with all that? Oh, what happened to the person that had on all that tax? Oh, he took it off. Oh, okay, I was like, no, it was somebody here with some other equipment on. All right, thank you very much, Ms. Stevenson.
For the records, Your Honor, Janice Stevenson appearing on behalf of Mr. Cleophas Jones. Mr. Jones, sir, please tell the judge your full name.
Cleophas Jones, Your Honor.
All right. Okay, so today is the day set for, a bond violation hearing, and, people appear to be ready to proceed. Is the defense ready to proceed?
Your Honor, if it please the court, I had an opportunity to speak with Mr. Jones this morning. I know that my partner did speak with Mr. Jones at his initial violation hearing, which brought about today's adjourned hearing. Mr. Jones, having had the benefit of counsel at this time, I believe wishes to waive his rights incident to this formal hearing and admit that he's violated the terms and conditions of the no contact order of the bond.
Okay, Mr. Jones, have you had an opportunity to speak with your lawyer?
Yes, Your Honor.
And, do you understand your constitutional rights?
Yes, Your Honor.
Okay,
Your Honor, I'm sorry, if it please the court, I have cautioned Mr. Jones about delving too deeply into this at the basis of the admission because the matter is still
oh, absolutely.
has not yet.
Oh, no, that's not what I was asking
Okay,
about.
okay, I apologize.
And having had an opportunity to, speak with your lawyer, she's indicated that you wish to, waive your rights to the bond hearing and admit that you have violated the conditions of your bond, which is the no contact provision. Is that what you want to do?
Yes, Your Honor.
All right, and you understand that there are witnesses in my courtroom right now where we could proceed to a bond violation hearing where the people would have to prove by a preponderance of the evidence, that you violated the conditions of your bond. You understand that?
Yes, Your Honor.
Okay. And you are voluntarily waiving your right to that right, not to the trial. So, no, you're voluntarily waiving your right to the bond here.
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything to get you waive your right to the bond hearing? Okay. All right, then the court will, accept a, admission of, responsibility for the violation of the bond hearing. I'm sorry, for the violation of the bond condition. And so that being the case, Ms. Ritter, what are you asking with respect to any alterations to the current bond condition?
Thank you, Your Honor. So, Your Honor, due to the admission, the people are requesting that the court actually change the personal bond to the cashier firm, change the curfew to house arrest, and keep the GPS center on. I don't know if the court did see the supporting documentation.
I have it, but I didn't look at it because we were having a hearing and I didn't know if some of it was gonna be inadmissible. Although I know hearsay is admissible with respect to these hearings, but I have it, here, but I didn't really look at it.
Okay, Judge, well, the court having that information, Judge, the court can just scan the text messages that were submitted, Judge. It's really a safety concern for the complainant witness, Mr. Wilson, and Ms. Wilson was present in the courtroom, Your Honor.
Let me ask this question. Are these people related?
So the situation was, Your Honor, from my understanding, Ms. Wilson was in a prior brief dating relationship with Mr. Jones. So
With the defendant?
Correct, so they are known to each other.
So if they were in a dating relationship, shouldn't Judge Eric be dealing with this?
Not necessarily, Judge. The underlying offense involves Mr. Wilson.
She's not a party to the case at this time.
Oh, I'm sorry, okay. Miss, who are these text messages to?
Those text messages are to Ms. Wilson.
And who are they relating to?
Mr. Wilson.
I got you, okay. And so the charge that's currently against Mr. Jones is as it relates to Mr. Wilson, who is in some way related to Ms. Wilson.
Correct.
Okay. And Ms. Wilson is the one that had a brief dating relationship. Okay, thank you. Okay. Before I hear from you, Ms. Stevenson, what is the current bond? What?
10,000.
10,000 personal GPS tether and no contact with planning business director or indirect. Okay, Ms. Stevenson.
Thank you very much, Your Honor. I guess I just want the court to know that having spoken with Mr. Jones this morning, he realizes that his failure to abide by any court order can land him in jail. So he's been sitting over there at the Wayne County Jail on the tether violation at this point for over a week. He has not been able to work. He is self-employed, Your Honor, and has not been able to maintain contact with his clients. He has created a situation which has severely and dangerously interrupted his life, and he's not interested in continuing down that path. I have reiterated to Mr. Jones how he has to really think of some way to move legally past this very delicate situation, and try to stay on the right side of the law. I think that he took the court order seriously, Your Honor. Had a very pretty ridiculous lapse in judgment that is about to cost him his business and therefore possibly his home. So
well, look like I'm reading these things, but look like everybody needs some help.
So I don't want to get into the specifics of anything because we're here because of what Mr. Jones needs to make sure that he does in order to not go back to jail.
All right, so let me just ask a question because I was trying to go through these filthy text messages. When I'm looking at the text messages, the ones that are on the left-hand side, those are not from Mr. Jones. Where are these? Okay, so like I'm reading this first filthy text message that is derogatory towards women and just derogatory in nature. And that I'm assuming that this is coming from Mr. Wilson, or is this coming from Mr. Jones? This first one that says she can't come to the phone right now. Who is that from?
Senator Furter.
I don't want him to talk to me. You can ask him, but I don't want him to talk to me.
That came from.
No.
Yes, that came from.
I need him to whisper that to you. I said I don't want him to talk to me. Okay, so who is that from?
From Mr. Wilson, the thing is from Mr. Jones.
And so the ones then that go, now I'm looking at what is on my sheet, the third page. And then, well, it's the fourth page because the report is the first page there. It's the fourth page and then on the right-hand side, it's two text messages back to back at 11:57. You see those? Who are those from? Allegedly. Let's see how they one is on the right, one is on the left-hand side, one is on the right-hand side. Who are the ones on the right-hand side?
Now the person
you may.
So those messages came from Corporal Smith trying to.
Trying to
bait Mr. Jones to see if that was him.
Okay, and then, so keep going. Then you see some text message say, I'm not a dog, I'm a fox. You see that? That's on the left-hand side. It looks like this right here. Okay, good. The ones on the left-hand side, those, can Corporal come up here today? Or the OIC, whoever know about these text messages, I'm just trying to get a understanding, just briefly. Oh, I mean, it could be both of y'all, but if Corporal know, if he was engaging in communication. So see, do you see, you have it, he over there on that side, right? I'm not a dog, I mean, I am not a dog, I'm about, who are those reportedly from? The defendant?
These were sent for me, the victim. Excuse me, everything on the left side is from the defendant, and everything on the right side is a reply
Either from you trying to,
from me
or, okay, thank you, okay. Okay. All right. Oh, I see, this is allegedly from, allegedly. Okay. Mrs. Stevenson.
So, Your Honor, at this point, as I've indicated.
Okay, go ahead.
Excuse me one second. All right. So as we've indicated, Your Honor, this unfortunately is a pretty complicated, messy situation, which Mr. Jones understands he has to take all the initiative that he's able to do to make sure that he abides by the court order, that he has no contact directly, indirectly, through third parties with the complaining witness, and having had the opportunity to sit in jail again for over a week and risk his livelihood has further cemented that fact in his mind, Your Honor. And I don't believe that Mr. Jones is interested in violating any court order.
Well, I'm confused, anyway, before. Okay, well, I don't know what his business is, but his language is like this, who wanna do business with him? But nonetheless, this is ridiculous. And then the way that a person refers to a person. I don't know what the situation is. I don't know what goes on in people's minds. I don't know. But I can't even imagine why, if he feels the way the text messages say he feels about Miss Wilson, why is he even bothering her? He literally calls her out of her name at every text message that's in this fact that you all have said was that he's admitted responsibility to violating. He hasn't admitted that all of these are from him. And it's one with a picture that purports to look like him under some text. And then he's referring to her in such a derogatory manner. Why are you even showing up in my space? If that's how you feel about me, if I'm your B, if I'm a B, if I'm a hoe, why are you even showing up in my space? Like, if somebody feels that way about me, then why are you even showing up in my space? Why are you even here? So, nonetheless, I don't know what the full situation is, but I think it's a shame that that these text messages are going back and forth. Additionally, on one of the text messages, so let me tell you what brings me pause and concern. It was a text message that said, pages aren't numbered, but I'm going to try to tell you. In my stack that was given to me So page 1, 2, 3, 4. Eight. Okay, so it's like 10, 11 in my stack, but it has a 4 at the bottom. It has a question mark at the top, like where the name is. It has a phone number that starts with 586. And then the first thing on that page says, "How are you faithful?" It looks like this right here. And there's a 4, a small 4 at the bottom of this page. And it says, "I may be on tether, but I still hit that SHIT home," right? That tells me that a person don't care that they don't tether. Tells me that a person says, "I'm on tether and I'm still gonna do what I wanna do." There's some disturbing things in here about stabbing. I don't know. I don't know what they all mean. And then there's some missed calls to the same phone number. It's just some nasty stuff like this. It's nasty. I didn't even know people talk like this. Okay. So Ms. Eason, I'm concerned that if your client has access to a telephone, which a tether can never restrict access to a telephone. It seems to me like he don't just care that he on a tether. So it sounds like to me that I'm gonna honor the people's request, at least for perhaps he won't do it. Perhaps he won't send these messages and engage in this conduct if he has to pay money to be out in the free world. This is ridiculous. You may.
Thank you. So, again, hearing the court's concern, and I think that might have been a little bit truer a week. So at this point, Mr. Jones has been over at the Detroit Detention Center. He's had to go over the Wayne County jail and wait for the tether. He got out of the Wayne County jail, is moving back on with his life, doing, things.
Well, he wasn't moving back on with his life if those text messages are true, but go ahead.
Doing some things that he's admitted to, that he probably should not have been doing. Then he sits over at the Wayne County jail again for a week. And then he's county greens, getting in the van, coming over to 36th District Court, appearing in front of the court. I think things are a little bit different today than they were over a week ago when Mr. Jones went to jail. I hear the court's concern. I believe they are valid concerns. But I ask the court to take into consideration that I think a week in the Wayne County jail has a sobering effect on people. And I would at least ask the court to give Mr. Jones the opportunity to demonstrate to this court, not to the magistrate, but to this court, who probably has this case moving forward, who is intimately familiar with now what's going on with this case, to give Mr. Jones an opportunity to show you that he can do what the court orders him to do.
And Judge, again, it's a very, very extreme situation where these victims are concerned for their safety of their kids. Just like the court read the text messages, there have been threats, killing, the complaining witness, his family, Ms. Wilson. It's really a safety concern for the people, Judge. And preventing from this case escalating to something with the felony docket, Judge, we're asking you to render people's request for a higher cash bond in the alternative, or in the alternative, GPS tether with house arrest.
And I guess I just think that the higher cash bond would do what has just happened. and send him to jail until he gets an opportunity to get the money.
Well, but maybe he need to be in jail for a minute, Ms. Stevenson. What the court has to consider are a few things. Defendant's ability to meet the bond, the danger to the community, the likelihood of conviction. And reading those text messages, he might be a danger to the community. Now, I understand that this is filed as a misdemeanor, and that part is not my business. And normally, I say, anybody who knows me knows that I believe the prosecutor needs to prosecute, the police need to investigate, the prosecutor needs to prosecute, the judge needs to judge, the defense attorney needs to defend. Everybody should stay in their lane. I can't make the prosecutors charge stuff as felonies. I don't know the strength of their cases, all of those things. I refuse to treat misdemeanor cases like they're felonies, right? Because the prosecutor has chosen to file a misdemeanor. So if you choose to file a misdemeanor, don't come to me acting like it's a felony. It is these cases here, though, these stalking cases, that for some reason also, I think the legislatures have to legislate. So the legislatures need to do a little bit of reevaluating, because they got gambling cases charging for a year and domestic violence charging for 93 days. That don't make sense. Okay. So I don't know, is he charged with aggravated assault? No, he's charged with stalking and communication. Are both of those 93-day misdemeanors?
I believe stalking is 1 year.
Oh, is it? And then aggravated stalking is a felony?
Yeah, that's
Okay, okay. So the stalking is a 1-year misdemeanor. But here's the thing that we learn by living, really, and by doing these cases. These stalking cases are serious. And then when a person is charged with stalking, and they know, this is what's the problem that I have. It's just like those jail calls that I never understand. When the person calls the jail and the announcement says, your call is being recorded. And then the people still talk on the phone and say all kind of stuff that they know the people are listening to. And then get mad at their lawyer because they can't get them what they want, because you done talked on the jail phone and said a million things. You already charged with stalking and then clearly sending text messages from a device to a device that we know the police are gonna look at. So that's confusing. That also says, I don't really have any fear of the system. And so now that you've been violated on the tether for no contact. So because he was already on the tether. That's the only reason he's here, because he was already on the tether. So they violated him on the tether. Now he's in the Wayne County Jail. Now all of a sudden he cares about his business. It appears to me that a true businessman would care about his business before he sends text messages talking about sucking dick and eating pussy and killing people.
I agree with that, Judge. And again, I guess as defense counsel, I don't think I can ever argue that jail is the right remedy, but if it is the right remedy in this situation, he's been in jail. And I am asking the court to take that into consideration, take that over a week of just an opportunity for the severity of this situation to have been made real to Mr. Jones. His freedom is in jeopardy, and he's already gotten a taste going back over to the county, Your Honor.
But wasn't his freedom in jeopardy when he first got this case? Wasn't he in jail when he first got this case?
Yes, and then he went back.
Okay.
And I don't think, I agree with you. It's a very strange thing that people contact people using the jail phone that they're not supposed to be having contact with. At least to Mr. Jones' credit, he didn't do that. And he could have, and he did. So I'm asking the court to have the sanction that has been imposed, that jail time that he's already served. Let that do the work that I believe it has done. We don't have any objection to the tether continuing.
Was the tether a house arrest tether previously?
I think it was a curfew.
There's a curfew that was 6 p.m. to 6 a.m.
Okay. So in 2024, where I'm probably one of 30 people who have a landline, the court would be outside of its authority to tell Mr. Jones that he cannot use his cell phone. And in a day and time where half of the population has never seen a payphone in person. Okay. But this is what I'm gonna do. I am gonna revoke the, what did you say? 2,000 person? 10,000 person. So he was on a $10,000 personal bond plus a GPS tether with a curve. So I believe whenever the court is gonna take a bond from personal to any dollar amount, that would be considered a reduction, no, an increase in the bond, I suppose. If I'm taking the bond from a personal bond to any dollar amount, that still seems like that would be considered an increase in the bond. So he's on a $10,000 personal bond. I'm going to change his bond to a $5,000, 10% bond, plus a GPS tether with house arrest. And I am restricting the use of his mobile device. He can only make, first of all, he shall not under it. Let me stop talking to you in the third person. You shall not have any contact whatsoever of any kind by any means to Mr. Wilson. What's his first name? Lance. To Mr. Lance Wilson. That also means do not contact Mr. Wilson. Is this his wife? Yes. Okay, what's her name?
Miss Carnisha Wilson.
Do not contact Carnisha Wilson. You don't know if they got married or not. So, and that's your problem. You see what I'm saying? You see what I'm saying? You getting ready to go, we getting ready to go south. It's getting ready to go south. It's getting ready to go south. It's getting ready to go south. Because here's also the thing. I think if people argue with me, then they don't care about what I'm saying. I think if people do what they do, they don't care about what I'm saying, and they're not gonna follow my instruction. And so then that makes me say this right here. Now, I am the person who, Mr. Griffin, I'm sorry, because I was taking a long time. Hold on, Mr. Griffin. Just tell me, Mr. Griffin, he went in right, I was looking at something. Bring him back out, bring him back out. Mr. Griffin, I was taking a long time with my bond here. Is she eligible?
Yes, Judge, she is eligible. There's nothing in her criminal background that would preclude her. My only concern is that she says she hasn't used any alcohol or drugs in the last 2 years, and the amount of months.
She don't know, she lied because she ain't been testing. So how we know if she not testing, she lied, she not being honest.
Right, and exactly, Judge, and the amount of time that she has,
she got a whole bunch of time because she is a 5-year, it's a 5-year probation misdemeanor. She got up to 5 years on probation.
So we good to go. I explained everything to her, and if you want me to give you a date, I can give you a date, Judge.
Yeah, give me a date again, because I'll go on the record after I finish with this hearing. I'm almost finished, but I didn't want to keep holding you up.
Judge, that'll be February the 8th at 9 a.m. with Judge Holmes, 133 in person.
Okay, thank you.
Thank you, Judge.
Yeah. Okay, thank you, Mr. Griffin. Okay. Yeah, so that's how I feel about that. And then let me tell you something, how else I feel about something. Why do you even care if them people married or not? Why you shaking your head when I'm saying they married? You didn't refer to this lady. I forgot. You didn't refer to this lady out of her name. Every time you send a text message, and then you acting like you caring that this young lady is where she married or not. I don't know if that's her real last name, Miss Wilson, or not. I don't know if she married to Mr. Wilson or not. What I know is don't contact her. That's what I know. What I know is your mouth is foul. Your language is foul. What I know is you disrespectful on a lot of levels when referring to somebody for whatever reason you still keep in communication in their life. That's what I know. So I'm gonna, and then in a minute, I'm gonna hurry up and end this hearing, because you're gonna start, getting yourself, staying in jail until the trial date. That's what you're working yourself up to. So let's just accept this. You're wrong. You're wrong for contacting them. You're wrong. I don't know if you sent all those text messages, because I don't know. Some of them could not be you. I don't know. But you're wrong for contacting them, and you're not going to contact them. And then let me be clear. If you contact them again, if you contact them, their cousin, their mama, if you contact anybody by any means, that means on that cell phone that you got, on social media, if you send out a message that looks like it's referring to them, if you post a post on Facebook, Instagram, Snapchat, YouTube, if you post a post that looks like it's referring to them, I'm gonna revoke your bond. I'm gonna revoke your bond. You're gonna sit in the Wayne County Jail, and we're gonna get you as speedy a trial as we can get you, because you're gonna be in that Wayne County Jail. So if you care about your business, if you care about being out in the free world, then you better stop. You better stop. I don't want to see another text message, a phone call. I don't want to see a message in a bottle. I don't want to see a social media post. I don't want to see a driving by their house, but because I was going down that street. None of it. None of it. Whatever street they live on, if you don't know what street they live on, then that's good. You're gonna be in the house anyway. Because if you go down that street and pretend like you didn't know they lived there, it's a violation of your probation. So I'm gonna put you on house arrest for your own good. I don't know what your business is, but if it means that you're supposed to go out into the world and move about the cabin, you cannot. You have to get permission every time. If you need to meet with some client or some prospective business situation, then you need to contact Ms. Stevenson, and she needs to submit a request, and then I need proof of whatever this meeting is. So that means you can't have any last minute meetings. That means you can't say, yeah, I'm gonna meet you tomorrow at 12, because you are not. If you violate this tether conditions that I'm setting now, I am gonna revoke your bond. and you are gonna wait in the Wayne County Jail until your trial date. If you violate these bond conditions, your bond is gonna be $50,000 cash surety, plus a GPS tether and house arrest, if you violate these bond conditions. So currently, your bond is $5,000, 10%. That means somebody got to bring you $500 to get you out of jail. And then when they bring the $500 to get you out of jail, it's gonna be a GPS tether. And then there is no curfew. There's no curfew. You are at home. This is a house arrest tether. You shall not use your cell phone for any purposes other than the necessary purposes. You shall not make any phone call to Ms. Wilson or Mr. Wilson. You shall not put any social media post. You shall not contact anybody that's related to them and try to send them any type of message. And I'm hoping that I'm being clear. Because please understand that it would be a shame, Mr. Jones, for you to sit in the Wayne County Jail for a year and then get found not guilty. Now you done sat in Wayne County Jail for a year for no reason. Okay, that's my order. Is there anything else?
No, thank you, Your Honor.
Nothing on behalf of Mr. Jones. Thank you very much, Your Honor.
Ms. Jones, if you get a new phone, don't try me. Don't you call them from any phone number.
I respect, no problem, Your Honor.
We're all set.
Thank you, Your Honor.
That also means the Wilsons, who apparently also now has his phone number, they did before, don't send him anything. Now, unless it's the police, unless it's the, what's your guy would be from?
Corporal Smith.
Unless it's the corporal or something that's, they're doing something because they received some information that this other phone number. Like if you get some, information that it's this other phone number and you're trying to do whatever you want. I'm not interfering with the police investigation. I'm saying y'all can't check that, y'all can't reach out to the man, trying to just bait the man into contacting you. That's what I'm saying. Okay, anything further?
No. I mean, on that, Judge, that's to all parties, like, no bait.
What you mean? It's only these parties that's baiting.
Okay.
What I'm saying is, I'm not gonna interfere with the corporal or the OIC with their investigation. Like if these people, I'm sorry, if the Wilsons get some, like, I don't know, one of these text messages or something, and they think it's him, he can reach out to them. I mean, it's his investigation. I don't know. You understand what I'm saying?
Almost.
Okay.
Okay. So you're.
The corporal said that a couple of these text messages, sir, don't do that, cause I'll flip right real quick. The corporal said that some of these text messages came from him.
Yes.
That he was trying to,
yes.
Confirm or whatever. What I'm saying is, if your client, or it might not be your client, so I'm not gonna say your client. If some person sends some messages to the Wilsons and they contact the OIC and then they decide to respond to these messages trying to see if it's your client, they can do that.
I'm clear on that.
Okay, yeah.
I don't have a problem with that.
And whatever else a judge allows, in terms of, whatever, search warrants and stuff, things of that such. I'm not trying to, I just wanted to make it clear that I'm not trying to interfere with their ability to investigate, but the Wilsons cannot reach out to Mr. Jones.
Understood.
Okay.
Thank you, Your Honor.
All right. We're all set. Did Mr. Jones have an upcoming court date?
Yes, February 20th, pre-trial.
Okay. make sure you know, it's February 20 in case he does post a bond.
I do it.
Oh, no, they don't be telling them. I mean, I should have told them on the record.
Oh,
February 20th. Make sure you tell, should I tell them on the record?
You know, if I can go back there, because I think that might, he had a question.
Okay, go back, go ahead.